Hi, good afternoon, everyone. Thank you for joining us here today. My name is Michael Williman. I'm a partner at the law firm Wigdor LLP, and joined here today by my colleague, Renan Varghese. And I'll let him talk a little bit about himself in a minute, but I've been at the firm for about 9 years, and over the course of the last 3 or 4 weeks, maybe 5 or 6 weeks now, we've been hosting these weekly Zoom/YouTube information sessions about the current pandemic, about how the current pandemic has created some new laws, how those laws apply to the workplace, and how some of the existing laws also apply to the workplace. So I'll let Renan speak a bit on behalf of himself, and then we can get going.
Sure. Thanks, Mike. Mike said, my name is Renan Varghese. I am an off-counsel at Wigdor. I have been at the firm for 5 years now, a little over 5 years now. And yeah, we thought it would be helpful as the entire world is getting adjusted to this new reality for us to provide a forum where people can have their legal questions answered. And especially now as industries in New York and across the country are starting to open up, I'm sure a lot of people have questions about their rights and about next steps. And we thought it'd be helpful to provide a little bit of guidance. And we will be going through a pre-prepared presentation that we have made. But to the extent that anybody has questions, please feel free to jump in at any point. There's a chat box you should be able to use. We will be made aware of your questions as they come in. And really, this is a service for you, the audience. So to the extent that we can help you, please let us know. Okay, and so why don't we start the presentation if there are no questions. As we said, this presentation is primarily about returning to work during and hopefully after the pandemic. For New York, we're a New York firm. A lot of what we're talking about is going to be related to New York and more generally as well. But currently, all of New York, except for New York City, is in phase 1 of the reopening plan, which includes construction, agriculture, forestry, fishing, hunting, and select retail for curbside pickup only. The phase 2 is supposed to start shortly. There was some confusion about when it would start. Yesterday, the governor issued some protocols and guidance governing the phase 2 reopening, which would include things like offices, real estate, more retail, vehicle sales, and commercial buildings. After phase 2, phase 3 involves the restaurants and food service industries, hotels, and accommodations. And lastly, phase 4 will be the arts, entertainment, movie theaters, Broadway, etc.
Just to speak a bit about these phases. Right now, we're in New York City. There's certainly, well, I guess the only thing is certain is uncertainty over when these phases are going to hit. But for the rest of the state that's beginning to open up, in addition to the 4 stages of opening, there are also a number of businesses, as you all likely know, that have been classified as essential businesses, which are permitted to run even in the pre-phase 1, pre-phase 2, et cetera, time frame. And so those who work for essential businesses or those who work for perhaps even non-essential businesses that the owners are claiming are essential, have already experienced some of the issues and some of the things that we'll be talking about today.
That's right. And New York is currently, we are out of the 7 points that Governor Cuomo has outlined that each region has to satisfy in order to begin phase 1. We have not satisfied 3 of the points. 2 of them have to do with hospital capacity, and the last one has to do with contact tracers. Mayor de Blasio has said he anticipates New York starting with phase 1 reopening in the first 2 weeks of June. So as Mike said, it's a lot of it is wait and see. In terms of where you can find more information about the phases, where your industry stands, and guidelines, the New York State has created this website. It is called forward.newyork.gov, which you should be able to see on my screen now. And on that website, you will be able to see, right now, this is the overview of phase 2, where it goes through, these are the businesses that are going to remain closed even when phase 2 begins. There are guidelines that all offices and businesses need to follow, which goes through what is mandatory and what is just recommended. This website also has information about, it has information about phase 1 and what will be required then. And it also has information about what employees can do about what their rights are, including the expanded sick leave policy that New York passed when the pandemic started in March, the expanded unemployment benefits under the Federal CARES Act, information about how you can get insurance in New York through June 15th, special enrollment period, and then other information that is relevant to everybody who lives in the city, including how you pay, issues regarding paying your mortgages, your rent, student loans, and testing. So we highly encourage everybody to go onto this website if you have any questions. In New York, this website is an invaluable resource that will help you at least figure out the first step and how to start on answering your questions, and hopefully lead you to more information as you need it. So we're going to go through some common questions people might have as this process goes forward and businesses start opening. The first question is, can my company force me to wear face coverings at my own expense? And the answer in New York is no. Your company can force you to wear a face mask, but the companies in New York have to provide those face masks to their employees at the company's expense. Then that being said, an employer cannot forbid you from wearing your own face mask that you procured yourself, as long as it's an effective face mask. Obviously, what is an effective face mask depends largely on the industry you're in. To the extent that you are providing an essential service, or to the extent that you're in, for example, the healthcare industry, you can't use the same kind of masks that someone who works in a general office might be able to use. People who work in offices, according to the guidance on the New York State website, are allowed to use cloth masks, bandanas, things that are much more informal, which obviously can't be used if you are in a medical situation. This is an important question I'm sure a lot of people have about whether they're required to wear a face mask at all times. And especially people who are fortunate enough to have their own offices might be wondering if they can take off their masks in the office. The legal guidance is that you are allowed to take off your face mask when you're in a situation where you can abide by proper social distancing protocols. So when you are when you're not within 6 feet of someone, if you're in a closed office. But again, there is some common sense that has to be used. It's harder to do if, for example, your office shares central air conditioning and the air is recirculated around the office. There could be issues with taking off your face mask, even if if you're physically not within 6 feet of someone. That could create problems that you really need to talk to your office manager or someone at the office about. Another question is whether your boss can require you to return to work even though you have been telecommuting and teleworking successfully. And can you be fired if you refuse to do so? Legally, there is no requirement that your boss allows you to continue to work from home once your industry is in the phase that is reopening. So you can't tell your boss, listen, I've been working from home since February or since March, and I've had no issues, and I just don't want to come in. I don't feel comfortable. I don't want to come in. Your boss can require you to come into work, but with a couple of exceptions. Another question, my employer insists on having certain employees return to the office, even though our industry is not yet permitted to reopen. I am worried that my boss will fire me if I complain about this. What can I do to protect myself? There are a couple of options. If you don't feel comfortable complaining to a manager or someone in the workplace, the New York State website that we went through earlier, forward.newyork.gov, has a complaint procedure in place where you can report your boss anonymously to the state, and the state can investigate. You also have the ability to go through the federal government and go through OSHA, which is required to investigate any complaints of general workplace safety violations. And again, you can make those complaints anonymously.
If sorry to interrupt you right in here, I would like to kind of talk a little bit about and maybe jumping the gun a little bit, but a little bit about some of the exceptions that Renan had referenced with respect to when an employer would be unable to require an employee to come back to work, so I'll run through those for a minute. I'm going to actually share my screen here. Let me see. Get this going. All right. So one of the potential exceptions that people can take advantage of are the disability discrimination laws. And the reason that these laws could be potentially applicable to someone who wants to work from home is if that person or a member of that person's family has a pre-existing condition that may make them more susceptible to serious harm or death as a result of the coronavirus. So as a general proposition, it's true, certainly what Renan said, which is that an employee does not have a right to work from home. And so under ordinary circumstances, and even under pandemic circumstances, most employees are not going to have the right to work from home. That said, as Renan also said, there are some exceptions. And one of the biggest ones potentially applicable to coronavirus-related situations are the anti-discrimination laws, and specifically those that target disability discrimination. Now, disability is a term that people may have a connotation or may have a thought or a definition in their mind as to what that term means. It's important to understand that under the law, a disability is something probably much broader than what you are thinking of. There are federal laws, state laws, and local laws in New York City that define disability, and the broadest of those definitions includes most ailments. And so to the extent that you are an individual who has an ailment, and that ailment could be a pre-existing condition that may relate to an increased susceptibility to harm from coronavirus, you can potentially ask your employer for what is referred to under the law as a reasonable accommodation. And a reasonable accommodation is where you're saying to your employer, look, I can do this job. However, I have a disability. I have an ailment that is going to make it more difficult for me to do this job if I am actually having to go to work, or more dangerous for me to do this job if I'm actually going to have to go into work. And so I'm going to ask for a reasonable accommodation to work from home. And whether or not the work from home request is reasonable is something that can only be determined on a case-by-case basis. But to the extent that that request is denied, or to the extent that someone is terminated or suffers some sort of adverse action for making that request, that is something that could potentially give rise to a violation of the law. So if you are potentially, if you have pre-existing conditions that make you susceptible to increased harm from coronavirus, or if your family member has such pre-existing conditions, one option would be to make a request for a reasonable accommodation if your desire was to not go and have to work in person and to be able to continue to work remotely. There are other areas in the law that will certainly be explored over the course of the next few months, including gender discrimination and whether or not requiring people to come into work and specifically people with children, requiring them to come into work rather than working remotely before schools and before daycares, et cetera, open. Requiring individuals to come into work who have children may have a disparate impact on women. And so you may have circumstances where a company's work from work policy actually creates a situation that is discriminatory. And so if you are being required to work from work and there is a reason that you don't believe that you should be required to work from work, it may be the case that you would have a claim under the law. And that's something that you could certainly explore with an attorney.
And as Mike was saying, it's important to engage in a dialogue, both if you're the employer and if you're the employee. Regardless of whether or not there is a legal right to work from home, especially at this point, if you do have an underlying condition, it's important to ask and begin that dialogue. And if you're an employer and an employee approaches you with information along those lines, then it's important to listen to the employee and engage in a good faith dialogue about whether or not continuing to allow that person to work from home is feasible. And if it's not, what else you can do to help that person. Another question is, if I experience COVID-19 symptoms, do I have to tell my employer? The answer to this is yes. Generally speaking, under the ADA, an employer can't make medical inquiries into physical conditions. But because of the unique challenges presented by COVID, the CDC has allowed for an exception to this when it comes to COVID-19 symptoms. So if you have symptoms, you are required to tell your employer. Your employer has to keep your medical information confidential, of course, but you as the employee do have an affirmative obligation. This plays into Mike's earlier question or presentation. Who is legally entitled to reasonable workplace accommodations to minimize the risk of COVID-19? As Mike explained, if you have an underlying condition that makes you high risk to contract COVID-19, if you have a condition, if you suffer from anxiety, depression, any kind of mental or physical condition that would be exacerbated by returning to work or by the unique challenges posed by your workplace, you do have a right to a reasonable accommodation from your employer, and assuming the accommodation doesn't pose an undue hardship to the employer. If I want to request a reasonable workplace accommodation, does the request have to be made in writing? You do not have to put a reasonable accommodation request in writing. You can informally approach your office manager, your human resources representative, and engage in what is called the interactive process, where you inform your employer of your medical condition, and you don't have to use the words quote unquote reasonable accommodation. You can say what your condition is and what help you need from your employer to deal with that condition. And then, like I said before, you and your employer need to have a conversation about what is and is not feasible.
One just piece of practical advice here, and again, before you follow, before you take any steps or actions based on anything that you hear today or see today in this presentation, that we would still advise you to speak with an attorney before doing so. But one piece of practical advice is that it may very well be advisable to put the reasonable accommodation request in writing, despite the fact that you absolutely do not need to. And the reason for that is that to the extent that you ultimately have that request denied, or to the extent that you are suffering some sort of retribution because you've made that request, you'd want to be able to prove that you actually made the request, and you'd want to be able to establish what the request was. We see, many times in litigation, once lawsuits are filed, and we're asking questions of the HR persons or the office managers who receive the reasonable request accommodations, that if the requests are verbal, there may not be the same recollection on behalf of that HR person than our client has. The HR person may say that the client never made a reasonable accommodation request, or may say that they made a reasonable accommodation request, but it was something different than what our client claims he or she requested. So although there are some downsides to putting things in writing, it certainly makes it more formal. Perhaps it makes it sort of a scarier process, a more intimidating and aggressive process. There are reasons to do that. So as always, I would recommend consulting with an attorney. I'd like to answer a question that we just received a short time ago. One question was, what if I am high risk and my job entails me going into a medical office? There is, as always, it's a case-by-case basis. But in this case, I would say that this individual is a strong contender for protection under the disability discrimination laws, at least insofar as he or she would probably be covered by the laws. So if someone has a condition that makes them high risk, it is likely that that ailment would fall within the definition of a disability under the law. Now, the question is, what is the reasonable request that would be made? There are, in this circumstance, I would say, two reasonable requests, or perhaps three, that could be made. One would be, can I work from home? Now, if you're in a job that is literally impossible to do from home, and in this case, that may be, if you work in a medical office, fielding calls and scheduling appointments, perhaps you can do that from home. If you work in a medical office treating patients, may ask for a reasonable request, cannot require the employer to provide it, but there's still a process that the employer would have to go through to have some back and forth, and you couldn't be retaliated against for making the request. The other two potential requests here would be, A, can I take a paid leave of absence for X number of weeks until the circumstance is such that it's safe to go back in? Or Y, can I take an unpaid leave of absence such that the circumstance is reasonable for you to return to work? And so if you were asking for a paid leave of absence, then the question is that reasonable? Now, one could see someone saying that's not reasonable to pay someone to not work. Or one might say, look, it's $1 trillion company and this person's income is not a significant deficit and it's only for 2 weeks, so that would be reasonable. Probably on that one, you'd probably end up in a situation where a court would find it to be an unreasonable request. So we get to my last request. Can we ask for an unpaid leave of absence? Well, that might not be the best thing for the individual in this case, not to be paid. To the extent that you can maintain your job so that you can go back to work and not get terminated from staying at home, it may be a better option than the alternative. And I've just received a bit more information. This person works in sales. As long as those sales, and I cannot imagine that those sales are occurring in person right now in medical offices, as long as those sales are occurring now over the phone or occurring over the internet or through Zoom or what have you, or as long as they can occur over the phone, through Zoom, what have you, then you would certainly have a strong claim that it would be a reasonable accommodation to allow you to work from home for a period of time. And any other specific questions, certainly you can always feel free to reach out to myself, to reach out to Renan, or to reach out to any of the other attorneys at our firm to ask any further questions. And of course, you can ask questions during this presentation as well.
Okay. Next question is, do I need to provide documentation of an underlying medical condition in order to request a reasonable accommodation? Once you inform your employer that you have an underlying medical condition, the employer is entitled to ask for documentation demonstrating that both the underlying medical condition and whether or not the accommodation you're requesting is reasonable and would address the challenges posed by your medical condition. So that is part of the interactive process. The employer does not have to just take your word for it that you suffer from a condition that requires a reasonable accommodation. Can my employer force me to stay home from work if it knows I have an underlying medical condition? Assuming that underlying medical condition is not COVID, then the answer is yes. Or sorry, the answer is no. An employer cannot force you to stay home if he knows that, or he or she knows you have an underlying medical condition, because that would be disability discrimination. They cannot take action against you because of any medical condition you have. Again, with the exception of COVID, they cannot force you to stay and work from home if you want to come into work because of a medical condition that you have. Can my boss ask me if I have an underlying medical condition to determine whether I should return to the workplace? Again, the answer again is no. Unless the medical condition is COVID, in which case your boss can ask you whether you have COVID to determine whether or not you can return to the workplace. Your boss cannot make these kind of inquiries into your personal medical conditions simply as a condition of returning to work. Can I request a reasonable accommodation if I live with someone who has an underlying medical condition? The answer to this is yes. You can definitely request the reasonable accommodation. And again, it really depends on the conversation that you and your employer have as to whether your request for reasonable accommodation is reasonable given the circumstances, given the medical condition that the person you're cohabitating with has, and given the requirements of your job, it may or may not be reasonable for you to ask to continue to work from home on that basis. Can I request a reasonable accommodation if I live with someone who is over 65? Again, you can request a reasonable accommodation at that point, but it is not the same kind of reasonable accommodation that is available to you under the ADA, which Mike talked about earlier. There is no requirement that your boss provides you with a reasonable accommodation simply by virtue of the fact that you live with someone who is over 65 years old. Can my employer place a plexiglass barrier around my workstation because it knows I have an underlying medical condition, even though it has not done so for other employees? The answer to this is no. Your employer cannot, on their own, place a plexiglass barrier around your workstation because of the medical condition you might have. Now, conversely, if you do have an underlying medical condition, it may be a reasonable accommodation for you to ask that your boss place some kind of barrier around your workstation so that you are not exposed, or to minimize your risk of exposure. But it is not something that the employer can do, because that would be discriminating against you In other words, treating you differently solely by virtue of a medical condition you have. It's important to note that discrimination isn't always just I was fired or I didn't get a raise or I didn't get a promotion. Any any treatment that differs between you and a coworker on account of an underlying medical condition would be considered disability discrimination. This also touches on a point that Mike had raised earlier. I cannot return to the workplace because my children are stuck at home and I have to take care of them. Can I be fired for this? This is not an issue of disability discrimination, but it is an issue where your boss, like I said before, your boss can require you to return to the office once your industry is in the appropriate phase of the reopening plan. Obviously, everybody had issues with schools being closed, daycares being closed, and summer camps being closed. It's difficult for a lot of people to be able to return to the office and leave there and find appropriate childcare. This would be the opportunity that both you and your boss need to engage in a discussion about what can be done to accommodate your childcare needs. And as Mike mentioned before, it could be considered a form of gender discrimination to refuse to allow a parent to work from home. In a lot of cases, that parent is going to be a woman. And if your employer treats their employees differently based on their gender, which includes childcare obligations, that could be a potential discrimination claim. And if you feel, sorry, go ahead.
No, it's no problem at all. I just wanted to kind of step back and not to get into the weeds too much, but to kind of explain the anti-discrimination laws as they pertain to this particular issue. As Renan said, there's no clear circumstance in which a law permits people to ask for or receive reasonable accommodations in connection with childcare, although certainly it is something that an employer may do just as a best business practice. But the law does prohibit gender discrimination, and where there is where there is just the term gender, there are basically two forms of ways in which someone can prove gender discrimination. One is called disparate treatment, and you don't have to remember these, but it's something to understand. One is called disparate treatment, where the behavior or the conduct is overtly discriminatory. So there is a policy put into place that only women have to return to the office. That would be a situation where it would be overtly discriminatory because gender is the defining characteristic that underlies the policy. But there are also policies that can be put into place that may be facially neutral. They may not on their face target women or target men or target individuals of a certain race or color or sexual orientation or creed, but nonetheless may have a disparate impact on a particular group of people. For instance, if you had a situation where an employer said that every employee must work on Sundays, every employee must work on Saturdays or Friday evenings or some other day that's associated for many people with has a religious meaning, that might be a policy that doesn't target an individual in its language, but has the impact of targeting someone. And so when an employer is working through getting the workforce back into place whenever their phase arises, to say that everyone just has to return to work, that policy doesn't specifically state that women have to do anything differently than men. But as a practical matter, that may end up being more difficult for many women than for many men. And just to be very clear, it is not universally the case. There are men who are the primary caretakers of children. There are men who are single fathers. There are certainly many men who will be impacted as well. But the studies show, and our experience in this area of law show, that the child care responsibilities fall disproportionately on women. And when child care becomes a problem, it impacts women in the professional workplace more than it does men. And so if you have a policy that requires everyone to come back to work, regardless of whether or not they have children, that policy could have a disparate impact on women, which may underlie a legal claim, as we've been discussing. It's not something that's for certain, but it's something that you may want to reach out to an attorney and discuss.
What types of reasonable accommodations can I request as a working parent? Mike touched on this a little bit earlier, but it depends on your situation. Even parents who have to work from home might still need reasonable accommodations, such as a flexible work schedule, so that they can work at a time when they're not the primarily responsible for providing childcare. They might require extra breaks throughout the day so that, for example, if they need to pump, or if there are other circumstances where they need a little more time to tend to their childcare responsibilities. What you need is really a case-specific issue, and it's something that you really need to discuss with your employer to see what is reasonable and what can be done for you to accommodate your childcare responsibilities. Can my boss demote me or reduce my pay because I requested a modified work schedule to take care of my kids? Your boss, for example, if you cannot work as much as you were able to, if one of your requests is, can I, instead of working 40 hours a week, can I work 20 hours a week? Your boss can reduce your pay in order to accommodate you. You do not have the right to your full compensation and all of everything that comes with it if you're asking to work less. There's no legal requirement. Your boss might still allow you to receive your full pay, and your boss might still allow you to maintain every aspect of your job, but part of it depends on what your actual request is and the circumstances that your employer faces as well. And can my boss fire me while I'm on maternity leave? There is no law that says you cannot be fired while you're on maternity leave. However, there is a strong inference in those kind of cases that the reason that you were terminated was because of either your maternity leave or your pregnancy status. And so in that case, we would highly recommend that you speak to a lawyer to get more input, to get legal advice unique to your situation about both your maternity leave and the circumstances surrounding your termination, because it can very well be a violation of the discrimination laws if you are terminated because of your leave.
Just to provide a little bit more sort of color and information about that, there are a number of laws that prohibit discrimination based on someone's pregnancy. So there are federal laws, the Pregnancy Discrimination Act. There are state laws in New York State and city laws in New York City that prohibit individuals from being discriminated against on the basis of their pregnancy. So that would involve a situation in which, because someone has become pregnant, that individual is then terminated or suffers some sort of other adverse action. And one of the things that we see that we've spoken about from time to time during these weekly check-ins on these issues is that employers often use crises such as this pandemic or financial straits or some sort of other calamity or catastrophe to justify layoffs. And sometimes layoffs are completely necessary. I mean, certainly there are businesses who right now are suffering tremendously and need to lay people off. But what we find is that it's not uncommon for businesses to choose to lay off people for unlawful reasons. So the business says, look, we need to get rid of someone in order to make the rent next month. Well, this person's on leave right now because she's pregnant. Let's just get rid of her because she's not working for us right now anyway. And so best to get rid of her. that is an unlawful decision. It's not unlawful to have a layoff. It's unlawful to choose someone because of their pregnancy status or because of their leave. And to the latter point, the leave laws the leave laws apply in circumstances beyond simply pregnancy. So there is the Family Medical Leave Act, which applies when individuals have to go out on leave because they're pregnant, but also allows people in certain circumstances, again, this is all fact specific, to take up to 12 weeks of leave in an unpaid situation, and come back to their job or to a job that's substantially similar. And so if you have a medical condition, if you have pregnancy, if there's someone in your family who you need to take care of because they have a medical condition, you may be able to apply for an FMLA leave. If you are discriminated against, retaliated against, terminated, pay cut, etc., pay cut when you get back because the leave is unpaid, because you've chosen to exercise your rights under the FMLA, that would also be unlawful. So you would have potentially a claim there for recovery from your employer. All of these circumstances, as we've said over and over, but it bears repeating, are extremely case specific. So there's no one size fits all resolution to any of these problems. And I would say, just sort of in closing here, and then we'll give a few seconds to see if there are any last minute questions, is that if you have any questions, as I said, you can reach out to myself or to Renan. I'm going to share my screen here now for a moment. As I mentioned when we started this, I'm a partner at a law firm called Wigdor LLP. Renan is an attorney here with the firm as well. He is of counsel. And if you go to our website, wigdorlaw.com, you can find out information about the firm. You can click on the team, and you will see all of our profiles. If you click on any individual person, you will see their email link is on our profile. You can also, if you don't want to email someone directly, click on the Contact Us section of the webpage, and you can get in touch with us through our contact box, as well as our generic contact email, our phone number, and when we're back in the offices, our address. So those are my parting words, and we'll wait about, 30 seconds or so to see if anyone asks a question, and of course, if Renan has any parting words.
We just want to thank everybody for taking the time to join us for this. And as Mike said, we understand that it is going to be an adjustment for everybody going back to work and resuming their life activities after this period of quarantining. And if you have questions, the number one thing you need to realize, especially as an employee, is that your rights don't stop because of the pandemic. You still have the right to be free to work in a workplace free from discrimination. You have the right not to be retaliated against. You have the right not to be harassed. And if you feel like any of that is happening, whether you're physically located in the workplace or not, you should certainly reach out to a lawyer, whether it's our firm or another, and discuss your rights and make sure that you are being protected. You should not allow anyone to take advantage of you just because of the situation that we're all in.
It looked like we have no questions here. So again, reach out to us directly if you need to. We will be back and we'll send out emails as to when our next information session is. Hopefully one of these weeks we'll have a bit more clarity on exactly when we'll be going back to work. But for now, I hope that everyone has a wonderful weekend and stay safe, stay healthy, and have a very good day.